All right. Welcome to my how-to series, Copywriting Your Work. This is a set one class. It is adult education related. That will be reflected on the certificate you receive at the end of class. The core knowledge category is personal and professional leadership development. And we will be focused on 7.1.6, the standard under PPLD for an introduction to adult learning principles. To get a certificate at the end of this class, you will need to first watch the entire video. Don't skip through or try to fast forward because you will miss something that you need to do to get the certificate. And then you're going to have to watch the video all over again to finish the steps. Step one, you're going to complete a reflective activity in a few moments. And you're going to send an email to me at oregonchildcare.trainer.annalise@gmail.com. Please pause this video and set up that email. The subject line should be how to copyright your work. And in the body of the email, you're going to need to write your name as you want it to appear on the certificate. And you're going to answer the reflective activity. Go ahead and pause if you haven't already and set up that email now. Step two, you're going to answer questions that I ask during the video. And no, the questions will not appear most of the time on the screen. You're going to have to listen carefully. Be ready to jot down your answers, and you can either type them into an email or you can scan or photograph your answers if you hand wrote them and reply to the first email that you sent me and include your answers to all the questions. I have carefully kept track of exactly how many questions I asked. And so I'm going to be looking for that exact number of answers and for answers that answer the specific questions I asked. Step three, when you are finished and you've got all the way to the end of the video, you will see a link. The link is also contained in the PDF. Once you've finished the video, you're going to use the Google form to complete the evaluation, and you're going to answer questions on that same Google form. Now, answering the evaluation questions is optional. You do not have to do that to get your certificate, but you will need to answer the questions, including what your name should appear as on your certificate, which should match the original email you're going to send me here in just a few minutes for the reflective activity. Yes, you need to have your name, and the evaluation is optional. I hope you will evaluate, and of course, even if you evaluate low, you're still going to get a certificate, and I'm not going to hold it against you. So please complete your evaluation. If you would like to send a separate evaluation, you can complete the answers and your name, and then not fill in the evaluation, submit, and go back and do a second copy of the form. Do not put your name in there. Just type in some sort of gobbledygook, right? Like A, B, C, D, E, F, G. And then for each of the answers that are required, just simply type in again that same A, B, C, D, E, F, G, or NA, or whatever. And then you can complete the evaluation without having to leave your name. Either option, whether you do it all in one or you do two separate completions of the form. It's up to you. It does not matter to me, whichever one you want to do. Step 4 is you're going to reply to that second email you sent me in step 2, and you're going to put in the body, finish the eval and answers, or something similar, so that I know to go back and check all of your work and issue a certificate. Generally, certificates are issued within 5 business days of when you complete step 4. If it has been 5 business days and you know for sure that the email oregonchildcare.trainer.annalise@gmail.com is the email address you used correctly, then please feel free to either text me or email me and nudge me to get you that certificate. For this class in particular, and several in the series, I want you to make note of the fact that the information contained in this training and on the copyright.gov website is provided for educational and informational purposes only and should not be construed as legal advice or as an offer to perform legal services on any subject matter. The content of this training contains general information, and depending on when you take this class in 2027, 2028, or later, may not reflect current legal developments or information. I, Annalise Shahan, make no warranty, express or implied, about the accuracy or reliability of information on the copyright.gov website or inside their toolkit. Recipients of contents from this training should not act on nor refrain from acting on the basis of the information contained herein for the purposes of education. Seek appropriate legal advice for any particular situation and facts individual to you as a participant from an attorney licensed in Oregon, or if you're watching this from outside of Oregon, an attorney licensed in your state. Any communications, particularly emails exchanged between you and I, arising from this training do not constitute legal advice and do not create or constitute an attorney-client relationship, because I'm not an attorney, between Annalise and any participant. And nothing herein is intended to create an attorney-client relationship, because again, I'm not an attorney, and shall not be construed as legal advice or an offer to represent any participant. This training is not soliciting legal clients and is not connected to any attorney or law firm. Now that that is out of the way, let's proceed to the reflective activity. I'm going to ask you a series of questions. Please either type the answers directly into the email that you've already prepared, or take the answers down on a piece of paper and send me a photo or a scanned copy attached to the email. Ready? Let's go. The first question I have for you is very simple. Have you ever made something, a document, policies, a lesson plan, a song? Have you ever made anything, created something, and had someone else steal it from you? If someone did do that, what is it that you created that was stolen? How did you feel when they stole that work from you? And if you've never had anything stolen, how do you think you would feel if you spent hours developing something like a lesson plan or policies or form, or you wrote a children's book and that content was stolen from you? How would you feel? Would you know what to do if your work was stolen from you and someone else used that work to financially gain or to otherwise build their reputation or use that work to their own personal benefit? Go ahead and pause, finish those questions, and then respond in an email to me. When you've sent the email, go ahead and come back to class and proceed. Now that you've completed that reflective activity and you've sent the email to me, that first very important email, let's move forward with class. So here's how we're going to flow through class. Your number one source for all things copywriting should be copyright.gov. That's the federal government's Copyright Office website. If you are using any other website other than copyright.gov, one, you're not using the right website because there is only one website to copyright and register your copyright through, and that is copyright.gov. Two, you are putting your information, your document, whatever it is that you've developed, at risk if you use any other website and you use any other entity to try to copyright your work. Because the only website, the only office, the only entity that you go through is the Federal Copyright Office, and their website is copyright.gov. So we're going to start on their homepage. Then we're going to dig into works for hire. This is a special topic for Oregon trainers and childcare trainers or trainers in general, but especially Oregon trainers who are working with Oregon sponsoring orgs. And yes, we're going to have some messages for Oregon sponsoring orgs and the Oregon Center for Career Development and Oro. That in particular, that information is contained in Circular 30. We're going to come back to copyright basics and talk about the gist of copywriting, the basics in Circular 1. Copyright notice, which is a solid starting point with some teeth for protecting your product, your work. That's in Circular 3. And then we're going to review Circular 2, copyright registration. Copyright registration is the next step up, and it gives you the power to litigate for damages when someone takes your work, if it's been registered by you. Next, we're going to talk about copyright fees in Circular 4 and how to calculate the correct fee to avoid your copyright application from rejection. Nobody wants to have to file a second time, so you want to make sure you do it right the first time. The next part we're going to cover is what happens after you copyright. And we're going to be looking at information in Circular 15A that is applicable to what we do with copyrighted materials that were developed in 2026. Last, we're going to take a look at the Copyright Registration Toolkit. And if you're looking to copyright any of your work, whether you're going to do a basic copyright notice on the work itself when you first create it, or you're going to do something more detailed like registration, then this Copyright Registration Toolkit developed by the federal government is your best friend. Now you can access all of these links in the PDF copy of this training here using this QR code. Or you can find the link to this PDF training below the YouTube video in the description of the YouTube video where I post this training. If you are using a different device to watch this training, or if you're using it on your phone and you have a second device that you can access the QR code through, simply scan the QR code with that second device and then email it to yourself, the link that pulls up. So scan the QR code, pull up the link, copy and paste the link into an email, and then use the device that you can print off of to open the email and download the PDF from directly from this presentation's PDF. If you have any issues with that or questions about how to do that, please give me an email or text me. All right, let's run through the materials on copyright.gov together because it is easier to take you right to the source documents than to recreate the wheel and add a ton of slides to this PDF. All right, copyright.gov, U.S. Copyright Office. If you don't see this blue banner in copyright.gov, both here at the top of the screen and in the bar, the search bar, you are not at the right link. There are all sorts of information. There's all sorts of things you can do, including read more about law and policy, register and find your registration materials. You can find recordation information and search copyrights that already exist. You can request licensing to use pre-copyrighted material from others, and you can do some research here if you're really needing to do that kind of work. There are also opportunities for employment. You can contact the office. There's more information about the office. So this is the official site. Notice that if you're going to be in Washington, D.C., you can make an appointment to visit the reading room, to submit claims or discuss copyright-related matters. You can do that in Washington, D.C. if you're going to be there. If not, then you probably want to use this website and access. You can search copyright records here. You don't have to use the links at the top. You can register your works. You can record transfers of copyright ownership and other documents pertaining to copyright. So if you're going to pass on a copyright or you're going to take a copyright from someone else, that's recordation. View copyright laws. You can learn about the Office of Copyrights, and you can check current fees here on the website. But we're going to go check out what is copyright here at Learn More. So copyright is a type of intellectual property that protects original works of authorship as soon as the author fixes the work in a tangible form of expression. What the heck does that mean? Well, it means that if you create something, a song, and you write it down, a poem or a story, and you write it down, a training, and you create a PowerPoint, or you create an evaluation, or you create a training proposal that you are sending to the Oregon Center for Career Development for approval, or you're creating a lesson plan, or you're creating your policies for your childcare program, or a contract for your program. Anything that you come up with, that you design or create, and you write it down or you record it, you put it in some form that others can view, and you're going to publish. either publicly or you just publish to yourself and your staff and your childcare program. Well, the minute that you create that original work based upon your own thoughts or maybe gleaned from research or taken from other places that are public property, public domain, don't steal another person's copyrighted art, copyrighted work. As soon as you put that into something that can be touched, that can be seen, it can be heard, it can be experienced by others, it's published, created, well, then you have a copyright on that intellectual property, on that creation, that thing that you've made. In copyright law, there are lots of different tangible forms of expression: paintings, photographs, illustrations, musical compositions, sound recording, computer programs, PowerPoints, books, poems, blog posts, and on and on and on. So if someone basically can read it, see it, hear it, view it, well, that's a tangible form of expression, and it's copyrightable as long as you aren't stealing someone else's originally copyrighted work. So be careful. Works are original when they are independently created by a human author, not by AI, and have a minimal degree of creativity. Independent creation simply means that you create it yourself without copying it. The Supreme Court has said that to be creative, a work must have a spark and modicum of creativity. There are some things that are not creative, however, okay? And those things are titles, names, although those can be trademarked through the state of Oregon, short phrases and slogans, familiar symbols or designs, mere variations of typographic ornamentation, lettering, or coloring. So if you're designing a logo, you might be able to trademark it, but you're probably not going to be able to copyright it. And if you're designing a recipe or a lesson plan, a mere listing of ingredients or contents is not going to be sufficient to copyright it. You'll note here it says, always keep in mind that copyright protects expression. It's never the ideas, the procedures, the methods, the systems, the processes, concepts, principles, or discoveries that is protected. It is the way that you express it, what you write down or record or create. It's that thing that you've created that expresses those ideas and processes and systems and concepts and discoveries. It is what people can see or what people can hear that can be protected by copyright. A work is fixed when it's captured. Okay? When it is captured in a sufficiently permanent medium so that the work can be perceived, reproduced, or communicated for more than a short time. For example, it's fixed when you write it down or you record it so someone can see it or hear it. Everyone is a copyright owner. Once you've created an original work and you fix it by either writing it down or recording it in some way so that someone else can see it or hear it, like taking a photograph or writing down a poem, recording a new song, at that moment, you are the author and the owner. Anyone other than you can also be a copyright owner. And so you want to be careful how you put these things together, who you put these things together for, and watch out that someone else cannot claim ownership of what you are creating. Copyright laws allow ownership through works made for hire, which establishes that works created by an employee within the scope of employment are owned by the employer. We're going to dig a little deeper into that in the next part of this training. The work made for hire doctrine also applies to certain independent contractor relationships and for certain types of commissioned works. I just want to throw out here, that if you own your childcare business and you develop something for your childcare business, or you own a training organization, a separate business entity that is acting as the sponsoring organization, or that owns your training program, if that business is the one that submits the work and is anything other than a sole proprietorship, because it is a separate business legal entity recorded and registered with the state of Oregon, it might own that property. So be very, very careful. Be very careful in establishing, before you fix your work, before you write it down, before you record it, who exactly this work belongs to. And if it belongs to you and you want to make sure that it belongs to you, the person who created it, do not include your business. Do not include a sponsoring organization, even if you own it, unless you own it as a sole proprietorship. Because a sole proprietorship is the only business form that does not have a separate independent identity from you, the individual. Copyright ownership can also come from contracts like assignment contracts, where you write a contract to assign or give the copyright to another individual, or from other types of transfers like wills or bequests, or because your LLC owns it and you sell your business to someone else. What rights does copyright provide? Well, owners of copyright have the following exclusive rights. They have the right to reproduce the work in copies or phonorecords. That means you can record it audibly. You can prepare derivative works based upon the work of the original fixed copy that you have. You can distribute copies of the work to the public by sale or other transfer of ownership, or by rental, lease, or lending. You can perform the work publicly if it's a literary, musical, dramatic, or choreographic work, a pantomime, or a motion picture, or other audiovisual work. My original work is my PowerPoint. It is not this copyright.gov website. However, this video that I've created, this video training, this training that I've created uses publicly sourced copyright.gov information, and I have packaged it in a training which I don't own the copyright information, but I do own the video, which cannot be shared, distributed, or for sale or anything else. Um, because the video itself, I am performing based upon my creation of this training. You can display the work publicly if you own it. And this right applies to the individual images of a motion picture, which a video is, or other audiovisual work. And I can perform the work publicly by means of a digital audio transmission if the work is a sound recording. And a copyright also provides the owner of the copyright the right to authorize others to exercise these exclusive rights subject to certain statutory limitations. So, for example, if you are the owner of the copyright for your contract that you use in your childcare program or a particular form, if you give others the right to use that in writing, you need to give it that in writing, that permission in writing, they have the limited right to, according to whatever you've written, use your original work to either reproduce or to create their own. And they have to follow whatever you've written in that email, the scope of what you're allowing. But you have the right to allow others to use your written work. The length of the copyright protection depends on when the work was created. The current law in 2026 is that anything created on or after January 1st of 1978 has a copyright term of the life of the author plus 70 years after the author's death. So if you create something today, you have a copyright term of life till the end of your life plus 70 years after your death. If you create something together jointly with your spouse or with your staff or with other childcare providers, that is a joint work. And that joint work, the term is for 70 years after the death of the last surviving author. So if you create a piece of work, a Google form, and you put the copyright notice on there with your other staff, and one of your other staff people is only 20 years old, and they live for 100 years, so 80 years into the future. That work, that joint work, the copyright lasts for 70 years after the 80 years that the staff person lives. So that's going to be 150 years. 70 plus 80, 150 years. If you create a copyrighted work under made for hire or anonymous or pseudonymous works, the copyright protection is 95 years from publication or 120 years from creation, whichever is shorter. We're not going to go into works created before 1978 because I have a feeling that there just isn't enough of that out there. And you're probably not worried about something created before 1978. So you can use works that are not your own. It is possible. All of us not only have created things that can be copyrighted, all of us have created things that can be copyrighted. Absolutely. When we read books, watch movies, listen to music, or use video games or software, we are using copyright protected works. So even if you're not the owner, you can still use those copyrighted works. And you can enjoy those copyrighted works. But if you want to use them and benefit, right? So you want to reproduce, sell, um, borrow that work to use uh, in your business, then you need a license. You need licensing to license those works. And that's something that you can do through the original author or whoever holds the copyright, and in some cases through the copywriting.gov website, copyright.gov website. Copyright registration is different than a copyright notice. You'll notice that at the beginning of my PowerPoint for this class, I wrote the C in a circle. That's the copyright, my name, and the date. That's copyright notice. Copyright automatically exists in an original work of authorship once that authorship has been completed or it's fixed, it's been published, right? It's been created. Even if I haven't published it out there publicly or shared it with anyone else, my authorship in that moment fixes the document or the recording, and the copyright is effective. But registration is a step that you can take to enhance the protections that you have through the copyright notice. And the most important step, according to the federal government and copyright law, is to register your work. Registering your work is not mandatory. But for those publications or other works, registration is necessary if you are going to enforce the exclusive rights of copyright through litigation. When you provide timely registration, it allows you to seek certain types of monetary damages and attorney's fees in a lawsuit, and it provides a presumption that information on the registration certificate is correct. Copyright registration is also a good public policy because it provides value to the public overall by facilitating the licensing marketplace that allows people to find copyright ownership information and allows people to license or use others' works to enhance and build on that work through new copyright and copyright ownership. Notice, the federal government is very clear that there is only one place to register claims to copyright in the United States, and that is the Copyright Office and this website. If you are going anywhere else, you are not actually registering your copyright, and no other entity can take your copyright for the federal government. You go straight through this website. That's it. Now, you might hire an attorney and have an attorney help you fill out and complete the copyright information, the registration. But I would be very careful about using other websites and other entities online to try to help you and assist you in registering your copyright. All right. Intellectual property protects creations of the mind, and copyright is one type of intellectual property. If you are creating something, you're designing something mechanical or a product that can be built and sold, okay, that's a patent. You're going to file with the U.S. Patents Office. If you're creating a logo, that's a trademark, and you're going to file with the state trademark office, Secretary of State in Oregon. Trade secrets are another type of intellectual property. And again, that's a different procedure. That's not copyright. All right. So you have to know what it is that you're trying to save and to have ownership rights of. All right. Inventions or processes, designs for articles of manufacture. Okay. If you create a new form of cactus, for example, a patent will protect it. Trademark law is words, names, symbols, or devices used as an identifier on goods and services. And trade secret law provides protection for valuable commercial information that is kept secret. So there are other intellectual property toolkits that you can get. All right. Document recordation is what you will do if you are going to change the ownership. Either you're going to assume copyright ownership or you're going to pass on copyright ownership. And if you're passing down copyright ownership to your heirs, they're going to need to record through that Office of Recordation here at the copyright.gov. They're going to need to do that, to fill that out. If they're terminating transfers or licenses, or they're going to take ownership, or if they want to renew the copyright after your lifetime and the 70 years. All right, so let's go on to circular 1. Let me enlarge my screen. All right. Copyright is that form of protection provided by U.S. law to authors of original works of authorship from the time the work is created in a fixed form. So the minute you sculpt it, or you write it, or you record audio and video, at that moment when that work is created, you have copyright ownership on that original work. Unless you have a problem with somebody else owning it. We're going to take a step back and we're going to look at circular 30. Works made for hire. There are two really clear situations that this circular covers. Works created by employees as part of the employee's regular duties, or when a certain type of work is created as a result of an express written agreement between the creator and a party specially ordering or commissioning it. When a work is made for hire, the hiring or commissioning party is considered the author and the copyright owner. Before we start circular 30, answer me this. Do you have a situation as a trainer that you believe might be a made-for-hire situation? And what do you think that made-for-hire situation is? Take a moment and pause and answer those two questions. When you register a work item, whether it's a document, a piece of art that you've created, a story, a poem, whatever, you generally have to identify who the author or the authors of that work are. The registration paperwork asks, who is the author or authors? And then you have to identify the party that owns the copyright of the work. Usually, the author is the person or persons who created the work you intend to register. But works for hire are an exception to this rule. For legal purposes, when a work is a work made for hire, the author is not the individual who actually created the work. Instead, the party that hired the individual is considered both the author and the copyright owner of the work. You have to be super careful to identify situations where you might be the author who created the work, but is not actually who is the author and the copyright owner of the work under the law. Whether a work is a work made for hire is determined by facts in existence at the time the work is created. And that means you absolutely have to know before you put the work down on paper or record a video or a record, or before you sculpt it or you build it or you make it. You have to know, how do I separate myself from any potential work made for hire conflict? And you need to be serious and intentional about making sure that you are creating that work, and the moment that it comes into existence, because somebody else could see it or they could hear it or both, you need to make sure before you take that step to create that you know for certain no one else can claim that work. There are two situations in which a work made for hire is produced. When the work is created by an employee as part of the employee's regular duties, and when a certain type of work is created as the result of an express written agreement, that's a contract, between the creator and a party specially ordering or commissioning the work. The gray area or areas here are what happens when you create a training, but the sponsoring organization, whether you work for them or whether you've just orally or in a written agreement agreed to do a training for them, what happens when they submit the training? You've got to figure that out. That is one gray area. And no, that is not a question that I expect you to answer at this point. That's one, right? When you're doing a training, when you're creating a training for a sponsoring organization. The second gray area is if you own the sponsoring organization or you own a training business that is anything other than a sole proprietorship, because then it is a separate legal entity from you, depending on whose name you put on it, whether it's your business's name or it's your personal name, depending on who you attach it to, you may not own it any longer. Remember that LLCs and partnerships, whether they're single member LLCs or multi-member LLCs, or if you've got a close corporation, which is otherwise known as a C Corp, or you own a corporation that is actually traded on the open market, so it's an actual corporation that has issued shares. If you are a limited liability partnership, limited liability, limited partnership, uh, whatever the case may be. If you've started a nonprofit or a not-for-profit, those are all separate legal entities from you yourself. They all have rights to ownership that are going to override or be superior to your right of ownership. And so you have to be very, very intentional when you create that work. At the time you create that work, are you putting your name on it, your personal name, or are you putting your business's name? Because if you put your business name on there, your business owns that work, most likely. Now, again, this is something you should seek legal advice on. If you're doing this on a regular basis, seek legal advice from an attorney and have them ascertain, given your business structure and your relationship with the sponsoring organization or the training entity, have the attorney advise you on how to publish your works, to create your works, so that at the time you fix your work, you are guaranteed to have copyright ownership. Otherwise, you lose all right under copyright law to call that original work your own, to reproduce it and to use it in the future to create other works. And quite frankly, to continue to train and do that training. Because when a work is produced under these conditions, this work for hire condition, the employer or the party ordering or commissioning the work is considered the author and the copyright owner. Do not make the same mistakes that I have made and given other people, other entities, other businesses, author and copyright ownership. The federal government says here that work made for hire can be complicated and has serious consequences for both the individual who creates the work and the hiring party who's considered to be the author and copyright owner of that work. And there are lots more information, but if this is a situation that you find yourself involved in, I would strongly recommend you consult with an attorney for more information. All right, so you can see here some of the law. Work prepared by an employee within the scope of his or her employment. So if you are working for a bank, okay, if you're working for a bank and you develop a cookbook, even though you're an employee, the cookbook has nothing to do with the scope of your employment as a banker or as a teller. The bank isn't going to get to claim that, even if you've made some notes during, your break at work and you've been doing this during your work day. It's got to be within the scope of your employment. Now, if you work for a child care program and you write a series of poems or a song or a pocket chart or a felt board, if you design something and that is within your scope of employment at that child care program, it is very possible that the child care program owns that work because you're an employee. And the gray area is, what if you own that child care business? Who owns the work that you've created? Well, that can be a tricky question depending upon your business structure. So you got to be careful. And then again, here are some examples of works specifically ordered or commissioned for use. Contribution to a collective work, part of a motion picture or other audiovisual work, a translation from, say, English to Swedish, or Chinese Mandarin to Spanish, as a supplementary work, as a compilation, part of an instructional text, a test, answer material for a test, or an atlas. Crazy, huh? If the parties expressly agree in a written instrument signed by them that the work shall be considered a work for hire, even if it doesn't use those exact same words, but if you put in a written instrument that you sign that you agree to develop something that there is going to be written or is going to be available for people to listen, or to watch or to listen, you are creating a work made for hire, and you will not be the author. You will not be the copyright owner. And you may lose your rights to that which you have created. Arguably, it would be better for you to simply create the material and then enter into an agreement to share or to license that material for a limited period of time and in a very limited way. Develop it first and then allow somebody else to use it. And then there's lots of definitions here, right? Instructional texts are literary. That means something you can read. Pictorial, something you can use, that's pictures that you can read by pictures. Or graphic work prepared for publication. That means it's written down and put into written form and intended to use in systematic instructional activities. So pretty much everything you put together that's used by the daycare kids, that's used in a childcare program, or that's used to develop a training and is used in a training, well, that's instructional text. All right, the scope of employment, all right, is a piece that we just talked about briefly. Let's dig into a little more detail here. The U.S. Supreme Court held that Congress intended these terms to be understood in light of agency law, which governs employer-employee relationships, and that the court should rely on the general common law of agency rather than on the law of any particular state to give meaning to these terms. Okay? So, if you end up having to litigate, to fight for your right to own the copyright to a particular piece of work that you developed, the court will look at what skill was required to create the work. Where was the work created? Did the hiring party provide the space, materials, or tools to create the work? How long was the relationship between the parties? If you own your own business, that could be a considerably long amount of time. Did the hiring party have the right to assign other projects besides the one that's under review? And could the hiring party direct the creator when and how long to work? Were you paid? How were you paid? Did the hiring party offer employee benefits? Did the hiring party remove taxes from the creator's pay? Did they withhold income taxes? Does the creator have their own business? Was the creator able to hire and pay assistants? What this is getting at is, were you an employee or were you a separate business entity that likely contracted? Was the work created as part of the regular business hours of the hiring party? Was the work created pursuant to the creator's usual tasks, their job duties? Was the work created during the creator's authorized work time? If yes, well, yeah, you probably don't own that work. The entity that tasked you with creating that work probably owns that work. And the court is going to look at the totality of the circumstances. So they're going to look at the answers to all of these questions and possibly related questions. And if you're going to bring a copyright claim, well, you're going to have to defend against these questions. Now, there could be hire at work, or there could be specially ordered or commissioned works. And those are considered a work made for hire if it satisfies all of the following four criteria. So that means if you go to court to litigate and any one of these cannot be proven, any one of these cannot be proven by the entity that wants to say that they own the copyright and not you, the original author, well, they have to establish that all four of these are correct. So the work must fall within one of the 9 categories of works listed above that are eligible to be specially ordered or commissioned as works for hire. They're going to give you that list here in a second. There must be a written agreement between the party that ordered or commissioned the work and the individual who created the work. Now, we're going to talk about these four in just a moment with regards to a sponsoring organization. And we'll dig deeper into this, okay? Generically, because every situation is slightly different. Again, remember, if you have a situation, you need to take that to an attorney. If you have a specific situation or you have a specific question that applies to only you, not just to general education, you need to take that to an attorney. So there has to be a written agreement. It cannot be oral, between the party that ordered or commissioned the work and the individual who actually created the work. In the written agreement, the parties must expressly agree that the work is to be considered a work made for hire. And they have to use some sort of similar language, all right? And the agreement has to be signed by all parties. So if a sponsoring organization submits your training, they may own the training proposal, but unless there was a written agreement between you and the sponsoring organization for the evaluation, the PowerPoint, the handouts, any specific things used in the training that you developed, because each one is likely to be considered on its own merits, you would have to have had a written agreement between you and the sponsoring organization, not just a phone call, but a written agreement, not just an email, not just a discussion in person, not just a text message, but a written agreement, a contract between you and the sponsoring organization. And they had to order or commission. Now, they didn't order you, they ordered this specific training PowerPoint or this specific training and these specific handouts and an evaluation and this and that, right? They would have had to ask for, request in the written agreement those specific pieces or a training that included those components. Now, the difference between ordering, right, which is where they just ask you to provide, or a commissioned work, is that commissioned work would be generally you have a little more control over it. And so that would be they ask for the training, right? The training, and then it assumes all parts of the training. Ordered is usually they've ordered a particular PowerPoint or they're looking for the evaluation and they list those things out and they're individually looking for those pieces. And they may include that they need the information from the proposal or the proposal itself. There has to be a written agreement. Now, it might be a very lopsided, one-sided contract, right? Where they ask you to provide these things, and the only thing that you're getting is you're not getting paid. You're just getting they're going to run this training, and you're getting the work load. That may be enough. And in that written agreement, the parties have to expressly agree. So there needs to say something like, the parties agree that this work will belong to or shall belong to the sponsoring organization, or that it's a work made for hire. And unless an attorney is involved, it's probably not going to say work made for hire. But it's going to say something about the parties agree that this work is to be considered the property of, or will become the property of, the sponsoring organization. And the agreement must be signed by all parties. So if you have a sponsoring organization that's trying to say, I submitted a proposal for this training for you, and then you developed this training. Well, that's probably not enough to claim ownership and copyright rights because you didn't sign the proposal. And here's my 2 cents. When the Oregon Center for Career Development says that the sponsoring organization owns your training, No, they own the proposal for your training that they submitted because that was their original work. What they do not own is the handouts, the evaluation, the PowerPoint, and all of the materials that you used as part of the training that you developed. Now, if the sponsoring organization developed any of those things, then they own the copyright. And if they gave you a license because they emailed you and said, hey, we'd like you to record this and to present this training, and here's the materials to present, and you recorded the training, well, you own the recording and they own the original materials that they developed. See how this can become sort of complicated? Do you see how that can be complicated? Does that make sense? All right. Authorship, if a work is a work made for hire, the employer or the party that specially ordered or commissioned that work is the author of the work. Copyright ownership. Again, if the work is a work made for hire, it's going to be owned. The copyright is going to be owned, and the author is going to be the employer or the party that ordered or commissioned the work. And that really stinks. The term of copyright protection for this work is 95 years from the date it was published. That means it became used, it was put out there, and somebody else besides the author, the original author, and the employer or the party that ordered or commissioned the work saw it. So somebody besides the business and the original person that created it. So 95 years from the date it's first used, or 120 years from the date of creation, whichever expires first. Doggone it. Most people who create something under work for hire law will never live to be able to wrestle that copyright term from the owner, from the business. Under certain circumstances, an author or the author's heirs can terminate an exclusive or non-exclusive transfer or license of the copyright in a particular work under these sections of the copyright law. But please note, these termination provisions do not apply to works for hire. So once you give up your rights to an employer or a party that has ordered or commissioned that work, that you've done the work for that business, you can't get your rights back. You can't get ownership and authorship back. So you have to, when you register, or when the copyright owner, author, who is the business, registers, they are going to base their determination on the facts that existed when the work was created. What that means is if a sponsored organization screws up, and look, they're only going to screw up once, right? The first time that you show them this and say, hey, you actually do not own this, and you challenge them, will be the very last time that they make that mistake. It will be the very last time. So they'll get smart and they'll know what to do next time. And so you're going to have to really watch what happens next time, and you're going to have to be really more careful. But This means that the sponsoring organization cannot go back, Oregon Center for Career Development cannot go back and try to rewrite history and say that the sponsoring organization owns your work if there was never a written agreement that specified work for hire or used the very similar language, and you and the sponsoring organization did not sign that agreement. Again, this argument will work one time, and then that sponsoring organization will never make that mistake again. That will work one time with the Oregon Center for Career Development. If you're trying to wrest away your training from a sponsoring organization, but it will not work a second time. So once you've made this argument successfully or unsuccessfully, you're going to be stuck with having to be very, very careful and very, very intentional in the future. Whoever processes your application for registration is going to accept your representation that the work is a work made for hire or that the work is not a work made for hire, unless the representation that you make in your registration is contradicted by information known to the person who's processing your registration or is available in the registration materials or in the office's records. So, if you are trying to register at the same time that, and again, this is probably going to work once and then never work for you again, because the sponsoring organization will get smart and they will start to file registrations. This will become a race in time. If you register first, you might win and get your copyright ownership and authorship. But if the sponsoring organization or the other business registers first, the office will have in their records that there is a work for hire, and you are unlikely to be able to retain a copy. So again, before you put a recording before you record it, before you put it onto a YouTube or a Zoom or however you're going to record it, before you create that PowerPoint, before you create that story or that poem or that test or that evaluation or whatever it is that you're creating, before you do that, you have to be super clear. What are the circumstances? What are the circumstances at the time that this work comes into being? The minute I put it to paper or to recording, to video, to paint, or whatever it is that I do, as soon as I create it, in whatever medium I create it in, it will be too late. So I have to know what I'm doing before I create it. The Copyright Office cannot provide legal status about the status of the work. Okay? You have to know ahead of time. And the best person to help you figure that out is an attorney who can provide legal advice based upon the facts that you have available at the time before you create it. Because again, once you've created that work, once you've recorded it, you've put it to paper, you've sculpted it, you've built it, once you've done whatever you've done and your work exists now, it's called fixed. And now it's too late to go back and try to figure it out, because whatever existed at the moment of creation of whatever it is that you're trying to copyright the moment of creation, it was too late. Everything was decided already at that moment. All right. Question 1. Was the work created by an employee? Well, already here you have a gray area. If you are a contractor or a trainer working for a sponsoring organization, or if you are the owner of the business that is going to use the document. So if, for example, I own my childcare program as a sole proprietorship. So anything that I create as part of my childcare program belongs to me because a sole proprietorship is the individual person. There is no separate business entity. But if you're a partnership, any form of partnership, general partnership, limited liability, limited partnership, any partnership, LLC, a single member or multi-member, C corp, a close corp, or an S corp. S corps do not legally exist. They're not separate legal entities. They are a tax filing status. So S corp isn't a thing outside of taxes. But any other form of business that you own may be creating a situation where this is a work for hire, even though you're not an employee technically on payroll. Are you an officer? And these are questions. These right here are questions for an attorney that you need to talk to an attorney about and have them help you assess. All right, so was the work created by an employee? Well, there's your conundrum. There's your legal question for an attorney. Did the employee create the work while acting within the scope of employment or within the scope of a contract, commission, or order the work? Yikes. Was there a written agreement? If not, that work is not a work made for hire. But see, these are questions in order because yes, proceed to question 2, no, proceed to question 3. The problem that you have between you and your business, your own business, whether it's a business, a training business, so it's, ABC adult education for early childhood educators, or it's ABC daycare. That question right there, was the work created by an employee? If in the spirit of the law, you were acting as an employee and you say yes, you have to say yes to that question. Again, that's a question for an attorney. And then you go to question 2, did the employee create the work while acting within the scope of employment? And you say yes. Oh my gosh, right off the bat, question 2, this is a work made for hire. Analysis done. So the question that you really need to ask an attorney is, if I own the business, am I creating work as an employee? And if you're creating a training for adults as part of a training business that you own, the answer could be, only the lawyer can tell you, yes. It was within the scope. If you are creating a sample policy as part of a training and for a training company, the answer may be yes. If you're writing a children's story to use in your childcare program, the answer might be yes. All right. And then the other questions here, 4, 5, and 6, and 7, you answer if there was a written agreement between the commissioning party and the creator of the work. All right. And you just keep going down. Now, the work that falls into one or more of the categories, these here, these are the types of work that fall under the work made for hire through a contract, through a written agreement. So you've got an atlas, a test, answer material for a test, a translation. Ouch. If you write a training and then you pay someone else to translate it, you better make sure that you have a written agreement to protect your translation. Your version of the training that's been translated into another language, you need to make sure that you, when you contract to have somebody translate it, if you want to retain ownership of it, you have to make sure you have a written agreement that you both sign that says this is a work for hire. Or you could lose if you do this orally or you don't follow through with these pieces. You might not be the owner of the translated version of your training. Have you ever had, this is question number 4, by the way. Have you ever had something that you developed translated? And if you did you get it in writing to retain ownership? Question 4 and 5. This is one of those points where you might be saying, ouch. For example, if you have written policies and a contract in your childcare program, and you paid someone else to translate those, and you didn't have this written signed agreement for work for hire, you probably do not own or have authorship under copyright law of those translated versions of those original documents that you created for your childcare program. And then here is their disclaimer, the federal government's disclaimer. Got a blank page. And then for further information, how to contact the Copyright Public Information Office or the Copyright Office. Internet, email, telephone, regular mail. All right, let's go back to copyright basics. What surprises you most about that Circular 30 work for hire? And looking back, do you have some situations in the past? You don't have to elaborate, but do you have some situations from the past that it now occurs to you maybe you don't own work that you thought you owned? Don't forget to email me the answers to the questions that I asked during class. All right, so what works are protected? Literary works, musical works, including accompanying words, dramatic works, including any accompanying music, pantomimes and choreographic works, pictorial, graphic, and sculptural works, motion pictures, and other audio visual works. Sound recordings, which are works that result from the fixation of a series, so I mean you create a series of musical, spoken, or other sounds. You put those to recording. Architectural works. Now notice it says these categories should be viewed broadly for the purpose of registering your work. All right. Good to go. And remember that a work is fixed when it is captured in a sufficiently permanent medium. So it's put into a form that the work can be perceived, reproduced, or communicated for more than a short period of time. And it is in that moment authorship becomes fixed when it's created. All right. The rights of a copyright owner are to reproduce, make derivative works. And so what does that mean? It means that if you create something that you copyright, you can then create sequels or prequels, or you can create new iterations. So for example, in 2028, let's say the copyright law changes and I take this class and I add the new stuff to it and it becomes copywriting your own work 2.0. Well, that's allowed. You can distribute copies of the work and you can send it to the public by sale, or you can license it, lease it, lend it, or transfer ownership. You can perform the work publicly. That means you can teach it if it's a class. You can display the work publicly. You can perform the work publicly by video recording it and transmitting it electronically. And again, you have the right to authorize others to exercise these exclusive rights, subject to certain statutory limitations. So you can allow people to use it, the materials that you've created, and you have rights to limit the scope for how long or to what extent that someone can share or use your materials. Again, remember that copyright does not protect ideas, procedures, methods, systems, processes, concepts, principles, or discoveries. So if it's things, intangibles inside of your own head, you can't copyright that. You can only copyright works that are fixed in a tangible form. So you have to put them down in some way that they can be read or viewed or heard. Titles, names, short phrases, and slogans, those are trademarked. Familiar symbols or designs, again, not copyrighted, trademarked. And you cannot trademark or copyright mere variations of typographic ornamentation, lettering, or coloring. So if you find a cool logo online and you just change the coloring, or you change the font, or you make one or two small changes, you know, move words around so that they're not located in the exact same place as somebody else's, well, you can't copyright or trademark that because it's not significantly different. It's not something out of your own original creation. All right. And you can't list ingredients or contents. You have to actually have created something that's usable. All right. And then again, this whole reiteration of this work for hire, because it's an important exception to the general rule for claiming copyright. And guess what? It is the most violated and used exception that authors end up losing their rights to their original work and they regret it. Most commonly because either they weren't paid for it at all or the value of what they created far surpasses the value of the employment or the contract, the value they were paid for it. Most commonly, these are things that are patented or copyrighted. When you work for an employer and you come up with this really brilliant idea and you realize after the fact that because you did it during work hours and it was the scope under the scope of your employment, that your employer actually owns this brilliant idea that you put down on paper or that you recorded or that you made something, that first demo model, and now your employer owns it. So we're going to skip this part about the work made for hire because we already went through that. Any or all of a copyright owner's exclusive rights or parts of those rights can be transferred. That's alienation or alienable rights. If you seek to transfer your rights or part of those rights, you must generally put them into writing and sign those rights of yours over to the other party or their authorized agent. If you are transferring a right on a non-exclusive basis, you do not need to use a written agreement. So, for example, if you're letting somebody, use it or say that I take this, I have this training and I tell another trainer, well, you can go ahead and train. You can use my materials and do this run this training yourself on September 15th of 2028. That's not transferring exclusive rights. I'm still retaining my right to train every other day up until that point and every day after that point. I'm just allowing that person to have it on a one-time basis. And that's a license. That's not a transfer of your rights. You can bequeath a copyright by will or pass it along as personal property. And you can convey your rights by operation of law. So you could bequeath your copyright in a will or put it into a trust, talk to a lawyer about how to pass it on. And oh, by the way, if you are married and you own a copyright that has some value, you probably want to talk to a lawyer about how to protect yourself in case you get a divorce sometime down the road so that your spouse does not have a right to claim a right due to the copyright being a marital asset. So, or common property, community property if you live in a community property state. So, yes. If you're going to transfer your rights, you can record a transfer of copyright with the Copyright Office through its recordation office. That's the Office of Public Records and Repositories. Although recordation is not required to make a valid transfer, it does provide certain legal advantages. And so that's where you're going to check out that recordation of transfers and other documents. If you think you're going to will your rights to someone else, to pass them on, bequeath them. And yes, that person will get those rights and then they'll have to renew those rights at some point down the road because after your lifetime there and 70 years, that copyright exists unless it's renewed. It does not exist after that your life in 70 years does not exist if your heirs don't renew it. Now, you are, for a filing fee, allowed to terminate your copyright transfer. So you can terminate an agreement that transferred or licensed your copyright to a third party after 35 years. Do not transfer your rights or give a license, a very broad license for like that person's lifetime. Don't do that. First of all, you're going to have to serve an advance written notice of termination to whoever you gave a transfer or a license to. And then you have to file and record a copy of that notice and pay the fee to the Copyright Office. So you're probably asking, well, gosh, Annalise, what do you do if you're going to let somebody use it? Well, here's the thing. Don't transfer it until you put it in, put it in a will, right? Don't transfer your rights unless you've got a living trust or that transfers upon death, or you're putting it in a will, right? And again, get legal advice on your specific situation. This isn't legal advice. This is general educational advice. And if you're going to let someone use it, you're going to license someone to use it, license it for a particular limited time period, put the license in writing, license it for a limited duration, and limit the use. So limit the number of people that it can be shared with. Limit that can only be used for educational purposes, or that can only be used in their own child care program and cannot be shared with anyone else outside of the child care program. Put limits on their license. That's called limiting the scope of the license, because a licensee is only able to share and use the copyrighted material that you are sharing within the scope of the license that you extend to that person. So again, if you need specific legal advice and you need help creating that license, contact an attorney and have them draft a copy of the license that you and the person you're giving the license to will both sign. The notice of termination must be recorded before the effective date of termination specified in the notice. And if you don't terminate, if you don't record the termination in a timely manner, the notice that you served upon that person will be invalid. And the author or the author's heirs will not be able to terminate the agreement if that person dies. And if you die, your heirs won't be able to terminate. This is serious business, especially if what you're developing can make you money. Works created on or after January 1st, 1978. The term of the copyright is the author's life plus 70 years after the author dies. And again, if the work is a joint work with multiple authors, the term lasts for 70 years after the last surviving author's death. And if you do something as a work made for hire or anonymous or pseudonymous, which means that you either create the work and you author it as anonymous, or you create a pseudonym, a fake name, like you call yourself Jane Doe. Well, the duration of copyright is 95 years from publication or 120 years from creation, whichever is shorter. But I'm going to tell you firsthand, 95 years is a long time to have somebody else take credit for your work. So be thoughtful from the very beginning. Now, we're not going to worry about works that were created before 1978. because that's going back in time. And you can't control anything you created before 1978. In 1978, I was 6 years old. I was 5 years old on January 1st of 1978. Certainly, I don't have any copyright ownership or authorship before that time period. Copyright exists automatically in an original work of authorship once it is fixed in a tangible medium. The minute that you put it to paper or you put it into clay or you record it, your copyright exists. But you can take a couple of different steps to enhance the protections of the copyright. And the strongest of that is registering the work. Now, what are some circumstances that you believe would encourage you or would make you want to copyright something? For example, I've said more than once so far in this training that you would want to copyright something that you anticipated was going to be worth income, was going to be worth money to you. And the more it's worth, the more likely you are to register it. But what are some other reasons, 2 or 3 other reasons, why you would be personally motivated to register your work? Take a few minutes and think about it. Seriously think about it. And then write those down and send those to me. This is question 8, if you're keeping track. All right, hopefully you've got 2 or 3 or maybe more reasons why you would be motivated to register your work. If you were not able to come up with any other reasons, I am going to share reasons back with you in response to your email, and you can share some more insight as to whether or not those would motivate you or not when I respond. But hopefully you've got a couple of answers and that you've responded to. So again, registering your work is not mandatory if you've created this in the United States. But registration is necessary to enforce the exclusive rights of copyright through litigation. So if you don't register, you cannot sue someone. You can't sue someone for financial damages. You can't sue them to try to get an injunction to stop them from using your materials, from republishing your materials, and from claiming ownership. You cannot sue for money, for injunctive relief, or even for restitution. You can't sue. The only thing you're going to be able to do is to file a complaint with the Copyright Office. And like every other federal office, they are busy. They are overworked. They don't have enough time to process all of the complaints. And you're not really going to get very far. Plus, the enforcement mechanisms that the federal government has, the agency has, are very minimal and very ineffective. So if it's meaningful to you, register your work. Pay the very small fee to register your work, and then know that you own it and you can go after someone to enforce your copyright rights. A copyright notice on your work has not been required since March 1st of 1989. But it is recommended because there are practical and legal benefits. All you have to do is write the copyright symbol or the word copyright, your name, and the first year of publication. Just remember, though, placing a copyright notice on a work is not a substitute for registration. Registration enables a claim to copyright with the Copyright Office. An application for copyright registration can be filed by the author or owner of the exclusive right in work, the owner of all the exclusive rights, or an agent on behalf of the author or owner. And something you might think about is if you're going to have a lot of these copyright registrations, you might want to hire an attorney on a very limited basis just to file these copyrights registrations. It's not too difficult. It's probably going to cost you a little something, but time is money. And if your time is very valuable, sometimes the small fees you're going to pay an attorney that does this kind of work, because copyright attorneys are not going to be charging what a criminal defense attorney charges, or an attorney who litigates all the time. Copyright attorneys' fees are generally going to be less, far less than attorneys who litigate. The application contains 3 essential elements: a completed application form, a non-refundable filing fee, and a non-returnable deposit. That is a copy or copies of the work being registered or deposited with the Copyright Office. So, in your own words, what are the 3 parts of the application? The certificate of registration creates a public record of key facts relating to the authorship and ownership of the claimed work. It includes the title of the work, the author of the work, the name and address of the copyright owner, which, if you're filing your own materials, you, the author, and the claimant or copyright owner are going to be the same. The year of creation, information about whether the work is published, has it been created, or has it been published? And published is it's been put out into the world for others to use. Has been previously registered, or includes pre-existing material. So, for example, if you have a training that you copyright in 2026, and then you update that and want to register the updated version, you would include the previously registered version and information. You don't have to include the whole piece, the material. You don't have to include the original record. You just include that there was an original record. You write that out, original record 2026. That includes pre-existing material incorporated into this new piece of work that I am registering now. You don't have to include the original material. You just write that on the application that you had a previous version that you've updated, and that previous version was registered and is incorporated herein, along with the new material that you've updated. There's an online application, copyright.gov, and there's a paper application for those of you that like old school. You can handwrite it or you can type it in. The advantage of using the online application is you have some help from the copyright.gov website to calculate the fees. And then not only does the registration create that public record of a copyright claim and puts other people on notice that you have this material copyrighted, before you file an infringement suit, that is where someone has violated your copyright, right? You have to have filed the registration. So before you can file in court, you have to file the registration. The registration establishes prima facie evidence of the validity of the copyright and facts stated in the certificate when registration is made before or within 5 years of publication. What does that mean? It means that if you register when you create the material, the work, and you've registered before you publish or put the work out there for other people to use or see or hear, or within 5 years of when you first put that work out there, the registration that you file and that is approved by the Copyright Office is all the evidence you need of a valid copyright. And the facts as they are written and contained in that registration establish everything you need to move forward with a claim of infringement against another party who's violated the copyright. The prima facie case or the prima facie evidence, that's what you have to establish sufficiently in what is known as a well-pled case in order for your case to move forward against the defendant that you are suing. So when you register before you publish or within the first 5 years after the date, the exact day that you publish, that record of registration that gets processed and approved by the Copyright Office, well, that gets you straight to litigation. No questions asked. When registration is made prior to infringement or within 3 months after publication of the work, a copyright owner is eligible for statutory damages, attorney's fees, and costs. If you registered after infringement or after 3 months after publication, you can't claim statutory damages, attorney's fees, and costs. You're not going to get financial damages. You're not going to be able to claim financial damages. You're not going to be able to go after attorney's fees, and you're not going to be able to go after the costs of litigation. You're going to be stuck with, most likely, the court being able to order a cease and desist to the defendant. Well, that's not very satisfactory, especially if that person has made money off of your copyright material. So again, you want to file at the moment of creation, before you publish your work, before you share it with the world, or you share it with anyone besides you. Your registration permits a copyright owner, permits you to establish a record with the U.S. Customs and Border Protection for protection against the importation of infringing copies. Now, probably not going to run into this, probably, but let's say some person steals your copy of your training and gets it printed and packaged overseas in China. And then they try to bring it back over here. They try to import that version. Well, U.S. Customs and Border Protection can go after those imported copies. Again, probably not something any of us that are here in Oregon are going to have to worry about, but you might become super successful as a training organization and your materials might start to be used worldwide. You might need that protection. Registration can be made at any time within the life of the copyright. Just make sure that you understand that the longer you wait, the less rights to claims you have when someone violates your copyright. And if you register before publication, you do not have to re-register when the work is published, although you can register the published edition if desired. So if you create and then when you go to get it published, you have a fancier, more polished copy, you might want to register the published edition in addition to the original edition. When the Copyright Office registers a work, it assigns an effective date of registration to the certificate of registration. That date is important because you really want that effective date to be recorded as prior to publication. That effective date of registration is going to be the day that the office receives in proper form all required elements. Okay? And what are those required elements that I asked you about above? Well, that's the application, the original, a copy of the original material, and the non-refundable filing fee. Again, that's the application that you print out and or that you complete online, the uploaded copy or replica of whatever it is that you've created, that's the deposit, and then the filing fee. And that date is not going to be set until all three of those are in the office's possession. Be careful to not publish before that date is set. And once you have turned in all three, and all three of those pieces have been received by the office, the Copyright Office, it doesn't matter how long it takes the office to examine the materials and mail the certificate of registration, because that date that is assigned is going to be the day on which the office acknowledges they have received all three: the application, the deposit, and the fee. Period. You do not have to receive your certificate of registration before you publish or produce your work. Nor do you need permission from the Copyright Office to place a copyright notice on your work. When you create your work, you should put that notice of copyright front and center at the beginning of your work and ideally throughout your work. But just know that the Copyright Office has to approve or refuse your application before you can file a lawsuit for copyright infringement, except in cases involving a non-US work. Well, we all live in Oregon or here in the United States, presumably. Would be great if my training started being used internationally, but okay. It is highly unlikely that any of us are going to create work outside of the United States. So because we are all creating work here in the United States, because we all live and work in the United States, that rule applies, that we cannot file a lawsuit for copyright infringement until our application is approved or refused. And then don't forget that if in order to seek financial damages, attorney's fees, costs, you have to file that action after the effective date of registration, and that the infringement of your copyright began after the effective date of your registration. And there is that 3-month grace period after publication during which all remedies can be recovered for any infringement begun during the 3 months after publication if registration is made before the 3 months ends. All right. Copyright notice, right? Copyright symbol, or P for phonorecords, or the word copyright, or an abbreviation like copper. The year of first publication of the work, or the creation if the work is unpublished. Again, do this before you publish. And the name of the owner. All right, your name, first and last name, middle initial if you think it's important. Notice should be affixed to copies that in a way that gives reasonable notice of the claim of copyright. Put it on the front, put it throughout if you can, but put it in a place where everyone sees it. It's got to be visible, and it's got to be easily seen. To be reasonable notice, it has to be able to be seen. People have to notice it. Because it puts potential users on notice that copyright is claimed for the work. Notice may prevent a defendant from attempting to limit liability for damages or injunctive relief based on an innocent infringement defense. One of the defenses to if you're accused of violating a copyright infringement is you could say, I didn't know. I didn't know. I didn't see the notice. The notice wasn't there. And that could be a defense. Well, by making sure that the notice is clear and that everyone will see it, that helps you prevent someone from saying, I didn't know there was a copyright. It identifies you, the copyright owner, at the time of first publication so that people seeking permission to use your work can ask you for permission or license. It's how people can contact you. It identifies the year of first publication, which can be used to determine the term of copyright. If you have done this anonymously, or you've published using a pseudonym, or if you're publishing work made for hire. And by putting that copyright notice on there, it prevents the work from becoming an orphan. And what that means is it identifies the copyright owner or the specifying terms of a copyright. Orphan works are original works of authorship for which the prospective users cannot identify or locate copyright owners to request permission. So if you do not want your work to be orphaned, and therefore copyright doesn't exist, or it does exist, but someone can defend against your copyright claim by claiming it was innocent infringement, you have to make sure that your copyright notice to people, if especially if you're not registering, gives people enough information that not only do they recognize that you own the copyright rights, but they have to be able to identify and locate you so that they can request permission to use it. So you've got to make sure that they can find you. So a great way to do that is to make sure that your contact information, an email, a phone number, email is the best, but it could be also a physical address, a PO box, where people can contact you in the future should they wish to use your work with permission. All right. And if you want more information on how to use a copyrighted work, then you can finish this document. All right, don't forget that publication is the distribution of copies. You're putting it out there for the public by sale or by transfer of ownership or rental, lease, or lending. You're offering to distribute copies to a group of people for purposes of further distribution or public performance or public display. You're using it to teach, or you're sharing it with your childcare families or your staff. And again, this is reiterating all of those timelines for when copyright exists. And there is no such thing as international copyright that automatically protects an author's work throughout the entire world. So you may be less protected in other countries. I don't know. Are you really worried about copyright protection in other countries? Do you think that that is something you might have to worry about in the future? Don't forget to be writing these answers down because you do need to include them. You do not need to include the questions that I asked, but you do need to include the answers and number each answer. And a little bit more information about that deposit. So all copyrighted works that are published in the United States are subject to the mandatory deposit provision of copyright law. As a general rule, this requires that 2 complete copies of the best edition of a copyrightable work published in the United States be sent to the Copyright Office for the collections of the Library of Congress within 3 months of publication. Now, this is pretty cool. So when you register something for copyright, you're including the application and the fee, the application fee, and the deposit. And the deposit is 2 complete copies of your best edition of copyrightable work. So this could be the recording, the video, the book, the poem, the PowerPoint, the training handout. And you're going to take 2 best copies, right? Clean, unedited, unmarked copies, original copies of whatever it is you're going to copyright. And you're going to send those to the Copyright Office. And they're going to deposit both of those copies into the Library of Congress. And the Library of Congress is going to keep 2 copies of your work. Now, you as the owner of the copyright may comply with this requirement either by submitting the best edition of the work when registering the work with the office, or you can submit the work without seeking a registration and solely for fulfilling the mandatory deposit requirement. And this is a public policy so that it helps ensure that the Library of Congress obtains copies of every copyrightable work published in the United States for its collections or for exchange with or transfer to another library. So even if you do not register your work, copyright law says that if you publish the work, you must send 2 copies to the Copyright Office within 3 months of when you publish. Now, if you're like me and you're a trainer and you've been a trainer for any significant period of time, you probably have 6 dozen, several dozen trainings and handouts and evaluations and even certificates related to trainings that you have published, meaning that you've shared them out there beyond yourself. And the law says, well, you're supposed to send 2 copies to the Copyright Office of any copyrightable work that's been published. And I'm guessing you've never done this. And neither have I. Does that mean my work isn't copyrighted? Well, no, not necessarily. It just means that I haven't provided those deposit copies. Do I have to provide those 2 copies? No, but I'm supposed to. And it further strengthens my copyright rights, my rights to my copyright rights. So maybe do that in the future. If you are a trainer, have you sent those 2 copies in the past? Or is this the first time you've heard of this provision as it applies to materials that you have originally published for training purposes? If you are a child care provider and you believe or want documents that you've created or things that you have created for your to use in your child care program, like lesson plans or a poster or a song or a book, if you have created those and you want those to be copyright so that you have a right that no one else can use those, have you sent 2 copies to the Office of Copyright, the Copyright Office? Or is this the first time you're hearing about this provision? Let me know. That's question number 11 for those of you who are keeping track. And then here are all of the extra bits at the end. Now, let's go to copyright registration. So Circular 2 is all about guidelines for submitting a complete, accurate copyright claim. And there's directions for completing the online application and the paper application. For submitting the filing fee, preparing your deposit copy, how to communicate with the Office of Copyright, and how to determine when your registration takes effect. All right, so the application establishes the basic facts of a claim, meaning whatever you put in the copyright application is going to be what you can use to file a claim if you believe someone has infringed on or breached your copyrights. It is super clear, therefore, that you complete an application as specifically and as accurately as possible. It serves the public interest. It provides potential licensees with accurate information, and it will decrease the cost of copyright litigation. If you fill this out, once you've got this application well and truly filled out, it opens the doors to claims that cannot be contested for lack of a proper pleading. In other words, when you file your application with very, very accurate, specific information, and everything is there, every I is dotted, every T is crossed, it means that your infringement claim against someone will proceed unhindered without objections or without sustainable objections from the court. You are strongly encouraged to apply online to register an individual literary work. So that would be a lesson plan or a document or a story or a poem or something that you created. Visual arts work, motion pictures, musical work, sound recordings, other performing arts work, or single serial issue. And then sometimes you can use the online system to register multiple works within one application. That's Circular 34. And when you come here to these links, you can always click on any of these blue words to find additional materials and circulars. To apply online, you complete the online application, submit a filing fee by credit card, debit card, bank account, or deposits account, and you upload your electronic deposit copy of your work, or it allows you to send a physical deposit copy. And it takes you through step by step by step. First, you establish a user ID and password and provide contact information. And then once you have your user ID and password, you go in and you complete applications. You can save your draft applications and you can review submitted applications. When you begin your application, you're going to choose the type of work that best corresponds to the work you seek to register. And there are some guiding questions and information built into the application that you can use to help you navigate. And then those questions that you encounter when filling out the application are based on the choices you make at the beginning of the application. After you submit your filing fee, you can either upload a digital copy of your work or send a physical copy or copies of your work by mail. If your work is published in a physical edition or physical format, you submit in the physical format even if the corresponding digital version exists. So if you have a PowerPoint like I do, and it's only electronic format, and the PDF is only electronic and available online, and other people can print it off, but my copy exists only in digital format, then I'm gonna submit the digital format. I can print it off if I want and send it in, but I'm gonna submit the digital format. However, if my work is published on paper, if I publish my work on paper, then that's how I'm supposed to submit it. Even if I have a digital version that exists. So be careful with how you do that. Ultimately, do I think they're really going to come down on you if you have a physical form, but you have a digital version, I mean, and you submit the digital version, I don't think so. If you're submitting a physical copy, it's super easy. After you complete the online application and you pay the fee, they give you a shipping label if you choose to submit your work physically. And then you send a shipping slip and deposit copy in the same package to the address on your shipping slip. The application will take you all through it. The paper application is not as helpful. There is a PDF copy. You can print it off. You can fill it in and print it off. The issue is that the online application walks you through the process. It guides you. When you use a paper application, you don't have that same guidance. And then applications for certain types of claims must be submitted on paper form. So mask works. So registration of mask works. Registration of vessel designs. Registration of works in which the U.S. copyright was restored. I don't think you're going to have to worry about the Uruguay Round Agreement Act. If you're renewing a copyright claim because you inherited a copyright claim and the copyright is going to expire because it's been that lifetime of the person who's deceased that you inherited from, plus it's been 70 years, okay. Maybe you inherited from somebody who inherited and it's been 70 years and you've got to renew that, right? Some types of group submissions, including group registration of databases, predominantly containing content other than photographs. So you see this, there's not really that many exceptions that are going to apply to you. And then there's a filing fee. The Copyright Office charges a non-refundable filing fee for each application. You can go to Circular 4, we're going to do that in a second, to find the filing fees. And actually the most current filing fees are going to be calculated using the online form. Payment of the fee is an essential part of the application because remember, until you have filed the application, the fees, and sent the 2 copies, 1 copy electronic or 2 physical copies to the Office of Copyright, your application is not complete. If your payment is canceled or your check is returned as uncollectible, the Copyright Office will cancel your registration and they will notify you. When you submit your application online, you can pay by credit or debit card, electronic check, or through a Copyright Office deposit account, which you can set up if you're going to do a lot of these. But if you use a paper form, you can pay by deposit account or check or money order made payable to Register of Copyrights. Currency is accepted only for paper applications submitted in person at the Copyright Office in Washington, D.C. So do not send cash. If you want to pay by debit or credit card or electronic check or the Copyright Office deposit account, you have to pay and file online. Well, the deposit account, a check or a money order, those will be accepted if you pay by paper, but not credit or debit card or electronic check. And I personally wouldn't set up a Copyright Office deposit account unless I was going to be filing a lot of these. Just not worth it otherwise. Don't forget that every application must be accompanied by 1 or more deposit accounts, or deposit copies, excuse me. That deposit refers to the complete copy or copies of a work that must be submitted to register the work with the office. And then once you submit it, it becomes part of the public record and can be viewed by members of the public upon request. The office uses the deposit to examine your claim and maintain a public record of the copyright. Below are factors to consider when you select and submit your deposit copy or copies. And for more information, you can see chapter 1500 of the compendium. Don't get too down in the weeds with this, right? So if you're registering an unpublished work, you submit one copy of it. If the work was published electronically and is available only online, you submit one complete copy of the published work. Office recommends you upload digital files to the electronic registration system rather than submit a flash drive, disk, or other physical storage device. Just upload it. And there's a list here of acceptable file types. The maximum size for each uploaded file is 500 megabytes. So if you have to break up your creation, chop it up into little pieces digitally. Don't zip. I don't think you're allowed to zip it. All right. And then there's Circular 61 if you're trying to figure out how to submit visual artworks, like a painting or a video, computer program. And remember that you need to do your best edition. So the material that you deposit for registration of a public work shall include two complete copies of phonorecords, complete copies or phonorecords of the best edition of the work. Now, remember that if you have not yet published, and that's the best time to send in your registration, you only have to provide one digital copy. Once you've published it, you have the responsibility of sending in two complete copies of the best edition of your work. So two complete copies of the published work. And you can find out more information from Circular 78. If your work was first published outside the United States, you can submit the work as first published or best edition. That's probably not going to apply to you. If your work was not published in any of the formats listed in the best edition statement, you can submit any published edition of the work. So we'll see what happens there. All right, so mandatory deposit. All right, mandatory deposit is that the Library of Congress has the authority to demand any work published in the United States for its collection or use. And so you have to mandatory deposit. When you register a work that is subject to mandatory deposit, you have to submit two complete copies of your work. Certain categories of works have special rules, considerations, or exemptions. And those are found in Circular 7D. So works that are distributed only online, advertising material and catalogs, electronic works like computer programs and computerized information works, floor coverings, wallpaper, and similar commercial wall coverings, textiles, and other fabrics. That's interesting. If you create greeting cards, postcards, or stationery, individually published lectures, literary, dramatic, and musical works published only in phonorecords. So that means if you create a poem, you never write it down. You just publish it by a recording, or if you create a song for your daycare, and the only place you put it down is into a record, a recording, a video, then Circular 7D applies. Multimedia kits, that could apply. Maybe a scientific or technical diagram if it's included in your training. Sound recordings. Tests. If you've created a toy, a doll, or a game. If you have work that you are publishing as part of a collective work, like collective for a training, right? So all the parts of a training. Yeah, Circular 7D, and check that out and read through it. This is why it's kind of important that you involve an attorney if you're really serious about copyright and really serious about being able to litigate and protect yourself from copyright infringement. So if you're really struggling, you can make a request for a grant of special relief, and you just have to do that in writing to the Copyright Office. And you just state the specific reasons why you cannot submit the deposit required and what you will submit instead of the required deposit. So if you can't submit, if it's all digital and you're submitting it before you publish it, that's easy, right? You just upload it with your application. The longer you wait to deposit, and if you'd wait to deposit until after you've published, especially if you've published it in a format that isn't digital, well, now you've got extra issues. So my advice to you is to publish while it's still only in digital form, and to deposit it before it's published, and to deposit it while it's only in digital form. Don't print it out yet, right? Don't pass it out in paper form. Don't go to class live and start handing the paper handouts out. No, keep it all digital. Do not publish it yet, and register and deposit your work in digital format. Easy, right? Easy peasy lemon squeezy. And then remember, if you publish later, then you should submit to published copies to the office, to the Copyright Office, so that it can be shared with the Library of Congress. But if your work is primarily in digital format and other people are printing it off to use for class, that's okay. It still just needs to be submitted in the digital format, because that's how you have published it. So you are going to provide it in whatever way you have published it. Be thoughtful about how you're conducting your business. And your request for special relief may be made either in the note to the Copyright Office field of the online application or by mail to the following address. And here you go. And then you can get more information about relief in Chapter 1500. If you submit an online application, you'll receive an automated email indicating their application and filing fee have been received, and you'll receive a similar automated message if you have uploaded your deposit through electronic registration system. It could not be easier. You're going to get email confirmation of all three parts that are submitted online. And if they don't receive your deposit, if your deposit doesn't upload or it's not received automatically, you're going to get an automatic message by email that your deposit wasn't received and you got to try again. It doesn't get any easier than that. If the office needs more information, then they're going to contact you by email or telephone. So make sure that your email address and your current telephone number are correct in your online application. And the office sends most of its correspondence by mail from the address cop-ad@loc.gov. So check all your folders, including spam or junk folders, for messages from this email address. Once the office registers your work, or if it registers your work, you receive a certificate of registration in the mail. And if the office determines that your work cannot be registered, you'll receive a letter explaining why your claim has been refused. The office cannot honor a request to deliver certificates by mail or through private delivery services. It's got to come through the U.S. Postal Service. And this is a requirement for, notice and due process under the 10th and 14th Amendments of the U.S. Constitution. For legal advice and for more information on that, please consult an attorney. Don't forget that the effective date of registration is the date that the office assigns based upon when your 3 parts of your application have been received. So when the deposit, the fee, and the application are received, that's the date that will be your registration and your certificate of registration. That is the date. And again, once you've got those 3 emails saying we've received all 3 parts, you can go ahead and publish or produce your work. You do not need to wait for the certificate to come, because that certificate is going to be dated from the day that all 3 parts were received by the Copyright Office. All right. Getting close to the end here. Copyright notice. Copyright notice is that piece that you're going to put on your copyright information, the copyrighted work. So don't forget, it's the copyright symbol or the word copyright or the abbreviation, the year of first publication, or the date of creation, and the name of the copyright owner. So copyright 2017, John Doe. It is your responsibility to use that. It's not required, but it's your responsibility. And if you fail to add that notice to your work, again, anyone who infringes on it can use that as an excuse that the copyright notice wasn't there. And they reasonably believed, given the nature of what it was that you created, that you meant for this to be part of the public domain and not copyrighted. For works first published before March 1989, the copyright owner was required to place an effective notice on all publicly distributed, visually perceptible copies. You don't have to do this anymore. You don't have to use the notice. But boy, you sure should. A visually perceptible copy is one that can be seen or read either directly or with the aid of a machine. So a book, sheet music, photograph, or film. And unfortunately, if it can only be heard, it's not a visually perceptible copy. So be careful. Now, if you're doing for example, posting on YouTube or social media, there are ways that you could, because they're videos and can be seen, there are ways that you can embed the copyright into the video. But if you're just posting a audio copy, you won't be able to put that notice. And make sure that you place the copyright notice in a way that will be permanently legible to the ordinary user of the work and could not be concealed from view upon reasonable examination. So if you're looking for more information on where to place your notice, you can see chapter 2200. The best place for a PowerPoint is at the bottom or the top or the side of every slide. Put it in the margins. On a video, make sure it's in one of the title slides and at the end. Find a way that makes it super visible and that it can't be covered up, and put it on there multiple times if you have multiple pages or multiple different documents. Your every handout. the certificate, the the proposal, put it on everything. Loud and proud and large and right there out in the open. An omission or mistake in using a copyright notice may not have invalidated the copyright to works published between January 1st of 1978 and March 1st of 1989. But this probably doesn't pertain to any of us because we're talking about 2026 and going forward. If you have not published the work, a copyright notice has not been required for published work. And the Copyright Office will register an unpublished work that does not bear a notice, regardless of whether that work was created before or after March of 1989. So make sure, again, that crucial timeline is before you publish. At the moment of creation, put that copyright notice on there, on whatever it is that you're going to be sharing, and then register it before you publish it. Take the time before you put it out there to register it. And make sure that before you put it out there, before you share it with anybody else, that you have the application, the fee, and the deposit of the digital document uploaded to your app online file or your online application file. That's how you really protect yourself. And then again, there's more information that we've already discussed on why you would want to put copyright notice on your work and embed it within your work. And then some additional information. Again, if you have questions, contact an attorney. If you need specific help, contact an attorney. Now, here is Circular 4, and these are the office fees. And this is fees, this outlines fees for different applications and different services that you're using the Copyright Office for. I'm not going to go through this whole document, but you can read about it before you go online. If you are filing, generally the standard fee is $65 for a basic claim, for a basic application. It's $45 if you're registering one work, not made for hire, and you are the only author and claimant. So if that fits you, that's $45. And online, when you use the website, it's going to take you step by step through filing, paying the fee, what the fee is, and then uploading your deposit. So that online form is invaluable. Circular 15A is about the duration of the copyright, and it goes into more detail about the life of the author plus the 70 years. You just want to be careful when you're reading through Circular 15A because there are dates. So things that were done on or after January 1st, 1978, things that were created before that January 1st, 1978, and there are all sorts of timelines. Timelines that are based upon whether it's been published by that date, on or before that date, or after that date, or whether it's been created but not published before, on, or after that date. This is only a 3-page document. You can read through it if you want more information about what happens afterwards. Now, the last piece, and this is probably the most valuable to download, is the Copyright Registration Toolkit. And this is going to take you through the essentials, understanding the process, preparing to file your application, filing your application, moving through the process once you've filed your application, and after you have your registration. So there's a nice little diagram here that talks about copyrights, patents, trademarks, and trade secrets. Depending on what you're trying to do, whether it's register your logo with the trademarks group, with that office, or you're trying to patent a toy that or something that you've created for mass production, or you've got a trade secret, probably not for childcare, but maybe, and maybe for training, I'm not sure. But if you're trying to patent a trade secret, there's something there. You're gonna go through that office, and then if you're looking to copyright, then you're gonna go through the Office of Copyrights. And there's some information on copyright basics, a compilation. Let me zoom in here a little bit. What's probably the most interesting information on this page is that a compilation is the creative selection, coordination, or arrangement of pre-existing material to form a new original work of authorship. So you're putting a bunch of things that already exist, a bunch of works that already exist into a new original work of authorship. So, for example, a directory of services for a particular region. So you're combining maybe a whole directory or list, database, for example, of children's books that talk about social emotional learning or certain topics of social emotional learning. A collective work is a type of compilation that involves several independent contributions. So that would be a newspaper or a magazine containing multiple articles, illustrations, and photographs is a collective work. A derivative work, okay, lawfully recasts, transforms, or adapts a pre-existing work's copyrightable elements. So, for example, you have a training and you turn that training into a book that you're going to sell. Or you take a pre-existing training and you update it, you put in some new information, add some new topics, or expand, and that's a derivative work because it arises out of the work that you previously did. And then there are, of course, those things that cannot be copyrighted. All right. Owning copyright versus registering copyright. This is basically breaking down and diagramming out for you, putting it into picture what these other circulars have talked about that we've already talked about. So in general, the work is created, the life of the author, the author's death happens, plus 70 years, the work enters the public domain unless it's renewed, unless the copyright is renewed. Sometimes there are multiple authors, maybe you and several co-workers, or you and other childcare providers work on it together and create it together. Well, the work is created, the last surviving author dies, 70 years passes, and the work enters the public domain, unless somebody renews the copyright. And then here's that work for hire. The work is created, and for 120 years, the work, after the 120 years, the work enters the public domain, or the work is published. And after 95 years, the work enters the public domain, but you'll notice here, it's going to be the same date. It's just whichever one happens first. Then there's a nice little table here about the benefits of copyright registration. Essentially, this toolkit is taking all of the information that's in the circulars and distilling it down into these nice, easy, readable one-pagers. Here's that copyright notice, a sample of that copyright notice. And again, they're referring to other videos, or here, this copyright registration video, or they're referring to circular 3 or another circular. Understanding the process, they're breaking the process down for you again. Each stage, the application, where you fill out where you have the 3 parts. and what circular or section of the website or a PDF you can find that information in. And then the examination that's done by the Copyright Office, the registration decision, and how you're going to be notified. And then again, due process under the 10th and 14th Amendments say appeals process. If you disagree with the office's decision to refuse registration for your work, you can appeal that decision, and here's your steps and how to do it, right? You request a first request or first review. If after the first review, then you can request reconsideration. You can submit a second request for reconsideration for an additional fee. Of course, they're going to charge you for this. And that second request is reviewed by the review board, 3 senior level staff members who will take a fresh look at whether your work is subject to copyright protection. The office does not hear oral arguments in support of a first request or second request for consideration. And the decision issued by the review board is considered the final agency action in the appeals process. If you disagree after that third step, that review board step, you can appeal the decision by filing a lawsuit in federal court. And you're going to need an attorney to file that lawsuit. And then copyright registration. Here's this infographic that shows you the flow. And from start to finish, you can see the steps and the decision-making processes. And that's all combined in Circular 10. If you click on the text version, it will send you to the directions, the text that discusses each infographic. All right. Do you need an attorney? The Copyright Office does not require you to be represented by an attorney. You may file yourself, or you may work with an attorney if you prefer. Our website contains all the information you need to submit your registration. But if you cannot find what you need online, our Public Information Office is here to help you Monday through Friday, 8:30 to 5 Eastern Time, except federal holidays. Staff members can conduct a walkthrough and help you with navigating the registration process, such as selecting the appropriate application and deposit. I really don't think this could be any easier, and they're there to help you. They just can't offer you legal advice. And legal advice would be very specific information where there's a possibility that something isn't as clear cut as you would like it to be. Contact an attorney first, get their information, get their advice. All right? Yes. And again, all of the things in red, all of the words in red are going to take you to an answer or more information. So if you're going to click and open in a new tab so you don't lose this document. Then get ready to prepare your file for application, get your fee, your form, and your deposit ready to go. Make sure you have answered these questions so that you're ready to file your application. This breaks down. You want a single fee for $45. Are you going to need the standard fee, $65 online, $125 if you're filing on paper? Another reason to use the online form. All right. And you can file multiple works on applications by a group of writers, short online literary works, photographers, musicians, and creators, group registration of unpublished works. If you're filing up to 10 unpublished works of the same type, you can file those for a single fee. And this list is not comprehensive. So as you can see here, so make sure that you check up on the single application tutorials, the standard application tutorials, and make sure you're checking up on these different registrations. And then here are all the reasons again why you want to submit online. Lower filing fees. You can draft and submit multiple applications. It's a faster examination by the Copyright Office. You've got electronic payment options and you get status tracking. If you file on paper, you don't know anything until they either reject or accept your registration at the Copyright Office, and you really don't have any way to know if the Copyright Office even received your application until your check gets deposited. And then some information about how you submit a copy of your work, filing your application. There's some video tutorials that you can watch on how to submit. And there are a ton of videos, actually. I think there's like a good 8 to 12. There's an FAQ and help text on the online registration. There's a walkthrough, is a copyright service. Again, they'll walk you through the application and help you fill it out. You can request a walk through using their online form right here. So if you want help, especially the first couple times you're doing this, all you have to do is fill out the online form and they'll respond within 5 business days to schedule your appointment. And you can get technical assistance either by calling the help desk or emailing them. Additional information about moving through the process from examination until and the decision-making process that the Copyright Office makes and goes through, all the way through communicating with the office, your application status and the other forms that you may have to use, and what you need to know after you have your letter of registration. Because once you receive that letter, the only thing you really need to do is make sure that you save those in a very safe place. I would recommend scanning and saving electronic copies, getting a copy on the cloud, and then making sure that your official copyright letters go into a fireproof safe deposit box, safe, or some other very foolproof, fireproof, flood-proof, tornado-proof place where you can save these documents. Because if you need them and you can't access a copy of them, well, that's not helpful. And of course, yes, you could request a copy at this copy of certificates from copyright.gov, but you don't want to have to wait. When you need the document, you want to be able to access it right away. And then if something is in error on your registration or you need to clarify additional information, you might have to file a supplementary application. You're not going to file a supplementary registration to correct minor errors like typos or adding articles, a, and the. And you're not going to use a supplementary registration if you want to correct information in the original registration that was incorrect at the time the registration was made. To learn more, hit Circular 8 up or watch the supplementary registration tutorial video. Copyright infringement occurs when a copyright protected work is reproduced, distributed, performed, publicly displayed, or used to prepare a derivative work without the copyright owner's permission. So that means maybe the sponsoring organization takes your PowerPoint and your class materials that you once used for them, and they create their own version of your training. Well, if they use your original materials that you copyrighted and it wasn't a work for hire, that's copyright infringement. And the Copyright Claims Board, located within the Copyright Office, provides a voluntary virtual forum to resolve copyright disputes up to $30,000 in total damages. It is intended to be a streamlined, less expensive alternative to federal court. And it might be your first choice, if you see there's a copyright infringement and there is less than $30,000 in total damages. To go to federal court, because that's where you're going to go on a federal copyright infringement, and those lawyers are pretty expensive. But if that's the route you want to go and it's worth it to you, you normally need a registration or a refused application from the office before you can file a copyright infringement lawsuit. And to bring a claim with CCB, you either have the registration from the office for the work or the works at issue, or you have submitted an application to register the work or works. If your application is later refused, the CCB will dismiss the claim, meaning without prejudice, meaning that you can then file it in federal court. If the application, if you file in federal court and it's dismissed with prejudice, you won't be able to bring that claim ever again to the CCB or to federal court. So you can get more information on the CCB facts document, the CCB handbook, and the Copyright Claims Board. You won't need to worry about this unless somebody breaches your copyright or infringes on your copyright. That means they violate your copyright rights. But the Copyright Claims Board, the CCB, seems like a really good alternative to filing in federal court. And remember that federal court takes years to process your claim. It's a lengthy process. It's going to be an expensive process because you're going to be paying a lawyer to go through every step of the way. The CCB is going to be less cumbersome. It's going to cost you less. And you're not going to need an attorney to go through that process. All right. Once registration is complete, there's no need to renew it at a later date. You don't have to take any action or pay fees to keep your registration in the Copyright Office's records. Your creative work does not enter the public domain until its full copyright term has expired, and your registration record can serve as proof of this information. And quite frankly, you will be gone 70 years before your copyright ceases to exist, expires. You are likely not even going to care at that point. So you can attend webinar events, check out their events webpage if you want more information. I don't know, you might get really into this issue and this topic, especially if you're a trainer and you're worried about sponsoring orgs taking your trainings or other trainers taking your trainings or people that review at OCCD taking your training. At least your proposal and developing something off of your idea that looks like or sounds like your training. So you might want to check out their events website. Or part of their website, you might want to check out their YouTube channel. They have a great resource guide here for circulars and engaging your creativity. They have specific pages for musicians, photographers, writers, visual and graphic artists. people who are creating websites. They have the Copyright Public Records portal to find copyright records held by the Copyright Office. So other things that are copyrighted, other people that are copyrighted. The registration portal for doing the application. You've got the tutorials, which are the videos, lots and lots of videos that are YouTube video channel linked, and Learning Engine video series, which is the Learning Engine is the Copyright Office's version of Educadium, so to speak. There is information in Spanish, the Copyright in Spanish website. You can go there and grab all their stuff. There's copyright law and policy. You can check out Title 37. You can check out the compendium, which has the administrative manual explaining the office's policies and procedures and practices, and then their policy studies and their policy guides and their memos at the policy site. And then you can subscribe to their official blog, Copyright Creativity at Work, and sign up for Newsnet, their digital newsletter, using the bottom link here. And then they've got their contact information. So exciting stuff. All right, that's a ton of info. Did you think that this topic was going to be so much information? Did you think this was going to be less information, more information? What questions, if any, do you have about this topic? Remember, I will respond to questions and I will send you to where you can find those answers, or I will back up those answers by citing to the Copyright Office's materials. What I'm not going to do is provide legal advice. So if you send me a specific question about your specific issue or your specific facts or your specific situation, I'm going to tell you to go check out an attorney. All right. Oregon, OCCD, Oro wants you to do a professional action or professional activity. So here's what I'm going to have you do. I'm going to have you take your policies that you have that you use in your childcare program, or policies that you use for an individual training, or a contract that you use for an individual training if you don't have policies. But you're going to put your statement, your copyright statement, your copyright notice on your policies or your contract or a PowerPoint, whatever you want to use, depending on if you're a trainer or you're working in childcare program. But send me a photograph of your statement on something you've developed, even if you've already published it long ago. Just show me that you can do it. And then list five documents or professional tools that you use, that you've developed, that you are going to put on that you're going to put your copyright notice on. And it can be 5 things that already exist, or it could be 5 things that you plan to create and put your copyright on before you publish them. So a list of at least 5 things, 5 works that you are going to put your copyright notice on. And if you have 1 or more new works that you are currently developing, tell me about 1 of those that you plan on actually registering. and why you plan on registering that particular work that you are developing right now, or that you're going to be developing in the near future. So don't forget to do that professional action, that answer the professional activity. And that is question 14 for those of you that have been keeping track. That should be answer 14 in your step 2 email response to class. Do not forget to finish with the eval and the questions. And that link for you is under this video on YouTube. So don't forget to look under this video on YouTube in the description. Look for that link for the eval and questions under the video on YouTube. You will also see the link for the PDF copy of this PowerPoint so that you can access the links I showed you at the beginning of class to help you find the Copyright Office website, homepage, and each of those circulars that we talked about and the toolkit. Please spread the word to trainers, and please advocate for admin rules to stop sponsoring orgs from stealing trainers' trainings. The current practice that Oregon Center for Career Development has is that if a sponsoring organization submits a training proposal on behalf of a trainer who has developed a training, that training belongs to the sponsoring organization. And there are sponsoring organizations supported by the Oregon Center for Career Development at Portland State University that have stolen trainings from trainers who had a pre-existing training that the trainer themselves had submitted the proposal to Oro. But when the sponsoring organization sponsors the trainer's training, the sponsoring organization writes a certificate. This is truly happened. And the trainer has lost exclusive use of their training because the sponsoring organization, and this tends to be CCR&Rs, Child Care Resource and Referrals, and those who do it, those CCR&Rs that do it, they know that they've done it. They now, once they've issued a certificate, say that they can also train that training and that they co-own that training with the trainer. And that's not correct. Because as you saw in this class, as I showed you using the materials straight from the Federal Office of Copyright, whether a trainer has put their name, that copyright notice on the training or not, that child care resource and referral should know that that training belongs to that trainer. They are the author and they are the holder of that copyright. And CCR&Rs and OCCD and other sponsoring organizations need to stop stealing trainings from trainers. And it's not just CCR&Rs that do this. There are other sponsoring organizations in Oregon and presumably all over the country that do this to trainers on a fairly regular basis. And it's happened to so many other trainers who've reached out and shared or commiserated that this has happened to them as it's happened to me multiple times, and not just from one sponsoring organization, but a couple. And it has to stop. So this training I developed very quickly over the course of a couple of days, and then registered, as I will be registering all of my trainings and all of my training materials going forward, because I'm tired of sponsoring organizations stealing trainings from me. And they can't steal these trainings from me because I did not develop these trainings as work for hire. So, two reasons why this training is important. Number one, so that trainers and childcare providers, owners who own childcare businesses, understand their rights. And at the moment that they create a work, can solidify and take up those rights and then enforce those rights if they need to. Well, that's number one. But number two is to raise awareness to business owners, the folks who own, and sometimes they are the authors as well. But for the business owners who own the training businesses, own their own childcare program, own their own training business, or are the sponsoring organizations, to raise awareness that they are stealing trainings. These are federal laws they are breaking when they steal, and they are infringing upon or violating a copyright owner and author's rights under federal copyright law. By raising awareness of the illegality of what is happening and helping everyone get on the same page, because knowledge is power, we can create an informed community where this isn't allowed to happen. And of course, number three, there's this collateral issue where if you own a separate business entity that has rights separate from your own individual rights, and you as the business owner is developing works that are copyrighted, who actually owns the copyright? And when does that copyright expire? And is that copyright alienable? Well, if it's the company, the business that you own that actually owns it, and you're not that business is not a sole proprietorship, it's not separate, or excuse me, it is a separate business entity from you, the individual. Are you setting yourself up where your business and not you owns that copyright? Therefore, you can't transfer that copyright interest to your heirs. Are you putting yourself in a position where you will lose money or someone else will make money off of your hard work, effort, and time. So those are the issues. And I'm hoping that by enough people understanding and knowing the law and knowing their rights, that these won't be issues going forward. Did you send an email with the reflective activity at the start of class? If not, get caught up. Did you send a second email responding to all the questions I asked in class? And there should be 14 of them that you are responding to in that second email. Did you complete the eval and answers using the link that you can find on the YouTube site underneath in the description after the underneath the video? Did you provide the exact name, first and last, as you want it to appear on your certificate in the first email and in the last email that you sent me, the third email? Does the name you provided match exactly to the name on your Oro account? Will Oro be able to match your name on your certificate to your Oro account? And did you email me to let me know that you'd finished the form online using that link so that I can send you a certificate? If you can say yes to all 6 of these, you are ready for your certificate. If you have emailed me that last and final email that let me know that you finished the online form with the link, let me know if it's been 5 business days and full 5 business days. So if you emailed me at 8 p.m. on Monday, Tuesday is the first full business day, and you can send me the following Monday an email after 5 o'clock after the business day ends if you haven't gotten a certificate. So give me 5 business days, please. That's it. I hope you enjoyed class. I hope you learned something. And more importantly, I hope you now know how to preserve your rights and how to make sure that your trainings and your work product that you develop for trainings or for use in your child care program remain your property and someone else isn't able to financially benefit from the work and the work that you've created. Thank you very much. See you next time.